Hi, so welcome back everyone. Let's make a start. So as I was saying, we have a mega revision of the Constitution. We have all of these topics for you. There's the 50 years of the emergency, the new vice president, the submission of the report of the Finance Commission, all of the news regarding Justice Yashwant Verma, right? We have the election of the VP, the 130th Constitution Amendment Bill, 100 years of the UPSC, and so on and so forth. So as you know, you're all preparing for the CLAT exam. So all of the things which touch upon the Constitution are relevant each and every year. So let's go through it. Now, let's make a start. So right at the beginning, the first slide I've just put as 75 years of the Constitution. Okay, so why is that? That's because India had become a republic on the 26th of January 1950, right? We'll take a look at all of the relevant dates in the next few slides. But keep in mind, why was this date chosen? Right? As you know, the constitution makers were ready with the draft. They had adopted the text of the Constitution on the 26th of November 1949. But they still decided to wait till 26th of January 1950. That is because they wanted to rhyme that date with the observance of the Purna Swaraj Day on 26th of January 1930. So that is the first time the Indian National Congress had observed the Purna Swaraj Day. Okay, so that's why this date was chosen. This therefore marks 75 years of the coming into force of the Constitution, right? 1950 to 1975. That itself furnishes us grounds to do the topic of the Constitution in detail. Okay, so let's make a start. First, let's have a quick look at the Constituent Assembly. Here on your right, you have the logo of the Constituent Assembly. I'm not sure you may have seen this. So the Constituent Assembly originally gets created under the provisions of the Cabinet Mission Plan of 1946. When it first meets, right, this is on 6th of December 1946. When it first meets, it has a temporary chairman. His name is Mr. Sachidanand Sinha. He was essentially chosen because he was the oldest, and his primary role as the temporary chairman was to swear in the members and hold the election for the permanent chairman. Okay, so once that was done, a permanent chairman got elected. That was Dr. Rajendra Prasad, right? He was the permanent chairman of the Constituent Assembly. As you know, he later went on to serve as the first president of India, as well as the longest serving president of India, and the only president to actually serve 2 terms. Okay. Now, the Constituent Assembly actually served several roles. Now, at the beginning, the Constituent Assembly primarily functioned with the task of drafting a constitution for the soon to be independent country of India. However, from 1947 to 50, it also served as the Dominion legislature, right? That's because the British had granted India independence from 15th of August 1947. But it would take a few years for a new constitution to come into being. So the status of our country in this time period was basically that of a dominion, technically under the rule of the crown, but essentially independent and self-governed. Okay. Later, after the constitution was adopted, it still took about an year and a half or more, about 2 years actually, for the first elections to get completed and for the first legislature to start functioning. Okay. So from this period, from the time of the constitution getting made till the first election was concluded, the Constituent Assembly also functioned as the provisional or the interim parliament. Now, just a few facts. I'm pretty sure you know about these already. So we have the chairman of the drafting committee. It was a committee of 7 members, but its chairman was the illustrious Dr. Ambedkar, who is fondly called the architect of the Constitution. By the way, interestingly, he also served as the first Minister of Law and Justice in independent India. Okay, so simultaneously with serving his role as chairman of drafting committee, he also served as law minister. Okay, now related to Dr. Ambedkar, he is a central figure to the Indian constitutional history. So we should always know the basics related to him. What is his autobiography called? His autobiography is called Waiting for a Visa. Okay, and when is it that we observe his birth anniversary? That is the 14th of April, which in the state of Tamil Nadu is also observed as Equality Day. Okay, now other than the drafting committee, there was also a standalone official who was given the title of the constitutional advisor to the Constituent Assembly. That was Benegal Narsingh Rao. Okay, that was Benegal Narsingh Rao, and he was the constitutional advisor. It was actually his job to visit the various countries of the world, seek their experience, prepare a basic draft for the consideration of the drafting committee. Now, interestingly, link this to another topic. He was also India's first judge at the International Court of Justice. Okay, so India's first ever representative at the International Court of Justice was also Benegal Narsingh Rao, Mr. B.N. Rao. Just in terms of the background and the history, credit for first formally proposing the idea of a constituent assembly goes to Mr. M.N. Roy. Okay, and other than that, the Indian National Congress, being at the forefront of the Indian national movement, they demanded the creation of a constituent assembly, elected constituent assembly, for the first time in 1934 and then later again in 1936. Right? This was part of the same resolution which rejected the Government of India Act of 1935. And it was the stance of the Congress, as well as the national movement as a whole, that a foreign constitution could not be imposed, and a constitution for India should be one that is made by the people themselves. Okay, so those are some of the basic details I wanted to cover relating to the Constituent Assembly. Let's now have a very quick look about the important dates relating to the Constituent Assembly. This is going to help us cover some current topics as well. So as you can see at the top, the Constituent Assembly gets formed on the 6th of December 1946. That's when the document would have been issued. And then it met for the first time on the 9th of December 1946 under the chairmanship, as we saw, of the temporary chairman, Mr. Sachidanand Sinha. Okay, now after this, a very important resolution was introduced and passed, known as the Objectives Resolution. So this was one of the initial pieces of business, and the idea was that this would lay out the framework for the work of the Constituent Assembly ahead. So this resolution was introduced or proposed by Pandit Jawaharlal Nehru, the first Prime Minister, on the 13th of December 1946. So you can see just very soon after the first meeting. Ultimately, this resolution was debated and it was passed on the 22nd of July 1947. So just less than a month before the date of our independence. Okay. Now, this date you should also link with the adoption of the national flag, right? The Tiranga, the Indian national flag, was adopted on the 22nd of July 1947, which is also the date of the passing of the Objectives Resolution. Okay, I hope this is clear. Who is that person who is most known in relation to designing the modern version of the Indian flag? His name is Pingali Venkaiah. Okay, Pingali Venkaiah is credited with designing the modern tricolor flag, which is the flag of the Republic of India. Okay, now I've gone through these chronologically. So next we get to September 1949. That's the 14th of September 1949. Right now, this date, I hope it's striking a chord with you this is the date we actually observe as Hindi Divas or Hindi Day. Please don't be confused. The Vishwa Hindi Divas is observed on the 10th of January, whereas Hindi Divas is observed on 14th of September. Okay. So there was a lot of debate on the language provisions. There were some who were big proponents of Hindi, whereas most of the others certainly stated that it was a diverse country with a lot of languages, and so there should be no one national language. Okay. Some people oppose this, but ultimately a compromise was reached. Okay, a compromise on the language provisions of the constitution. This compromise is popularly known as the Munshi Iyengar formula. Okay, named after K.M. Munshi and N. Gopalaswamy Iyengar. Okay. So what was the compromise? The compromise was that there would be no one national language of the country. The union, that is the union government, would have Hindi as the official language. However, English could continue to be used, and the form of numerals would be the international form, not the Devanagari form. Ultimately, it was decided that states would be free to have their own official language or languages. There would be no singular national language. Okay, so these came to be adopted by the Constituent Assembly on 14th of September 1949, which is why we today observe the 14th of September as the Hindi Divas. Next we see here is the key date of 26th of November 1949. Right? We are fortunate to be standing today, I think barely 2 days away from this date. So this is the date which you find mentioned in the preamble of the Constitution. Okay? Because it is on this date that the text of the Constitution was adopted. Okay? Now, even though it was adopted, as I mentioned earlier, most of the provisions would come into force only on 26th of January 1950. Okay? Now, due to the adoption of the Constitution on this date, we observe this day as the Samvidhan Divas. Okay? As you all know, and we'll be looking at it later, the government has announced the observance of Samvidhan Hatya Divas as well. I don't know about the advisability of that. Certainly seems like a bad idea, since we already have a day to commemorate, celebrate, and respect the Constitution of the country. Anyway, so Samvidhan Divas is on the 26th of November 1949, and coincidentally, this is also observed as the National Milk Day due to the birth anniversary of Dr. Verghese Kurian, who is known as the father of the White Revolution, okay, which relates to milk. Now, between the adoption of the text and its coming into force, there was one sort of final sitting which was held on the 24th of January 1950. So this date represents the last session of the Constituent Assembly. It was also the day when the national song and the national anthem were declared, were adopted, and the first president of India, Dr. Rajendra Prasad, was also elected. Okay, so keep in mind this date, 24th of January, as the date of election of Dr. Rajendra Prasad as the first president, the date of adoption of the national song and the national anthem, that is Vande Mataram and Jana Gana Mana, respectively, and it was also the last session of the Constituent Assembly. Okay, I do want you to make sure that you link this with the observance that is going on. What is that? 150 years of the Vande Mataram. Okay, so as you know, starting this year from the first week of November, the government is observing 150 years of the creation of the poem Vande Mataram, written in Sanskritized Bengali by Bankim Chandra, and this is found and later published as part of his book, his novel called Anand Mat, which is set in the backdrop of the Sannyasi rebellion of those times. Okay, so please do link this with 150 years of Vande Mataram, We have, of course, covered this in one of our prior videos. Okay, so please do go ahead and check those out. Finally, we see that the constitution comes into force on the 26th of Jan, which is now, of course, observed as the Republic Day. Remember that the total time taken to draft the constitution, this is one of those weird things which we all have to remember for competitive exams, like the exact number of days taken to frame the constitution. So what is that? 2 years, 11 months and 18 days. Okay, 2 years, 11 months and 18 days. Just as a side point, I have mentioned that the 26th of January, coincidentally, it has also come to be observed as the International Day of Clean Energy. So this is a UN observance, like India has not created it, but the International Day of Clean Energy also happens to be on the same day as the Republic Day of India. Okay, so I hope all of these are clear. Through it, we have also been able to take a look at the Hindi Day, the Milk Day, as well as the Clean Energy Day, apart from the topics directly linked to the Constitution. Let's now go ahead. So this is a quick one. As you can see on this side, this is actually the original copy of the preamble, which is why you see here that it only mentions the words sovereign democratic republic. Now, of course, you know that the Constitution describes India as a sovereign, socialist, secular, democratic republic. Another one of those things which you must remember as is, for the life of me, I could not tell you why, but the conventional wisdom on these exams is that you must remember this in this order. India is described in the preamble as a sovereign, socialist, secular, democratic republic. Now, the words secular and socialist, as well as the word integrity, all of these three were added to the preamble by the 42nd Amendment Act. Okay, you can see here it says fraternity, assuring the dignity of the individual and the unity of the nation. So the 42nd Amendment added the word unity and integrity of the nation. Okay, so these three words, socialist, secular and integrity, all these three words were added to the Constitution in the preamble by the 42nd Amendment Act. Okay, I hope this is absolutely clear. The preamble largely mirrors the objectives resolution. It does have some extra details. Remember that the preamble is a part of the Constitution. There used to be some controversy on this topic, and some early judgments of the court even said that the preamble is not a part of the Constitution. But this matter came to be settled, and even in case of Nanda Bharati, the basic structure case, it was made clear that preamble is not only a part of the Constitution, it is fundamental and important as an aid to interpret the substantive provisions of the Constitution as well. Finally, I just wanted to mention Article 1, which describes the names of the country. What are those names? India and Bharat. Okay, so in the Article 1, India and Bharat are seen as translations of each other. India, the name of the country in English, and Bharat, the name of the country in Hindi. There has been some ridiculous controversy on this topic over the last few years, with people sort of suggesting that there is some controversy or competition between these names. I think that's frankly weird. Our country has two names, India and Bharat, and both of these have a tradition of history behind them, much longer than the British. Okay, anyway, so India, that is Bharat, shall be a union of states. Okay, that is the description of the country. So the country is described in two ways: a sovereign, socialist, secular, democratic republic, and a union of states. Remember, India is described as a quasi-federal country because it has many features of federalism, but it also has certain unitary tendencies. Unitary meaning favoring the center or favoring the union. Okay, so just keep this in mind. India, that is Bharat, shall be a union of states. Intriguingly, the word federal or federalism does not actually appear in the constitution, though over time it has been held by the court that, of course, federalism is implicit in our constitution. Okay, let's now move on. This is just to give you a very broad structural guide to the constitution. So the way I like to divide and remember it is, the initial parts of the constitution deal with the basics, right? Part one, what is the union and what territories are in it? Who are the people who are citizens of this union? What are the fundamental rights which the citizens have as well as other persons? What are the goals of the state? That is the directive principles of state policy. And finally, part 4A, that is the fundamental duties. Okay, the duties of the citizens. So those cover sort of the basic things: the country, its territory, the citizens, their rights and their duties, as well as the objectives of the state. Then the next portion deals with the structure of the country, the structure of the government. So we get part 5, the union. This is where you find parliament. This is where you find the president, vice president, the ministers, the executive, as well as the union judiciary. Part 6 gives us the states. This is where you find the governors, the chief ministers, the state legislatures, Vidhan Sabha and Vidhan Parishad. Then part 7 is empty as of today. Part 8 has the union territories. Then think the next level of organization. Part 9 is panchayats. Part 9A is municipalities. Part 9B is cooperatives. And finally, part 10 is the scheduled and tribal areas. Okay, so remember, basics part 1 to 4A. Then part 5 to part 10 tell us the structure of the government. Then think of the other important institutions. We find those in the part 14, deals with the services and creates the Union Public Service Commission. Part 14A deals with tribunals. Part 15 deals with elections and creates the Election Commission of India. And the last part are the other important provisions. Part 17 dealing with languages, part 18 dealing with emergencies, and part 20 dealing with amendment of the constitution. Okay, so the idea of this is to give you a broad structure, and when we do the various news items, you can relate these various parts with those news items. Just remember, the last portion of the constitution are the 12 schedules. So originally there were only 8, but now there are basically 12 schedules of the constitution. Okay, so I hope this gives you a good structural idea of the constitution. Let's now go ahead. So I'm going to take up the amendments and some questions related to that at the end. But first, I wanted to deal with this topic, that is the 130th Amendment Bill. Okay, this is one of the latest constitutional amendments that has been proposed. It's been introduced in Parliament and referred for further discussion. Okay, so I'll just take you through the basics of this one. First, remember, we've already seen the part which relates to amendments. What is that? Part 20, which contains only one article. That is Article 368. Okay, so amendments are governed by Article 368 of the Constitution, which is found in Part 20. Okay, on amendments, just remember, there has been a historical tussle on whether Parliament has the ultimate right of amending the Constitution. The Supreme Court says otherwise, and over time has interpreted the Constitution to include the basic structure doctrine, which was propounded by the case of Kesavananda Bharat. In this, the court said, yes, Parliament has the power to amend any part of the Constitution. However, it may not alter the basic structure of the Constitution. So what is the basic structure? the court articulates these as principles: separation of executive and judiciary, the independence of judiciary, checks and balances, federalism, secularism, independent and free and fair elections, judicial review, the rule of law. All of these foundational principles are described as part of the basic structure or basic features of the Constitution. So with that backdrop in mind, let's come to the 130th Amendment Bill 2025. So what does it seek to do? Okay, what it tries to do is to make provisions for situations where the PM, the CM, or any other minister of the union, state, or union territory, when they are arrested for a certain period of time for serious offenses, then it provides for their removal. Okay, so we'll just get into it. I'll describe to you the conditions. Okay, so let's have a look. So 130th Amendment, first of all, applies, as I said, the PM, CMs of states or union territories, ministers of states or union territories. Okay, now, two important conditions need to be satisfied. Number one, the person should have been accused of an offense punishable with imprisonment, which may extend to 5 years or more. Okay, so think of it. At the time a person is being arrested, obviously they have not been convicted. We don't know what punishment or sentence they will ultimately get. We don't even know if they will be convicted or acquitted. So all we have is the maximum punishment for a particular crime. So what clause 1 tells us is that for the provisions of this constitutional amendment to apply, the offense for which a person, being the minister, PM, CM, the offense for which such a person has been arrested and detained in custody, that offense must be one whose maximum punishment is at least 5 years. Okay, whose maximum, think of it this way, the maximum punishment should be at least 5 years. Okay, so this is the easiest way to understand clause 1. Okay, now the second condition is that he should have been arrested and detained in custody for such an offense as we have discussed for 30 consecutive days. Okay, this is important, 30 back-to-back days. So think of a situation where somebody is arrested and detained in custody for, let's say, 29 days, but then released, and then again arrested 10 days later. This previous period of 29 days does not actually count. Okay, it has to be 30 back-to-back days that a minister, PM, or CM has been arrested and detained in custody for an offense punishable with at least 5 years maximum punishment. Okay, so that is how you should understand the conditions for this. Okay, next, let's have a look. Now, what does it say? Essentially, the objective of the amendment is that if you have been arrested for a consecutive period of 30 days for a serious offense, as we have discussed, then the amendment wishes, or the objective of the amendment is that you should no longer continue as the PM, CM, or minister. Okay, so how does it ensure this? What it says is that if we are talking about a minister of the union government, they have to be removed by the president on the advice of the prime minister, but the PM's advice must be given by the 31st consecutive day that the minister is in custody. Suppose the PM fails to advise the president, the minister shall stand removed automatically. The same thing happens at the state level between CM, governor, and minister. So if a minister of a state government is arrested and detained in custody for a serious offense for at least 30 days or for a consecutive period of 30 days, then the CM must recommend to the governor that they be removed by the 31st consecutive day. However, if this advice is not received, then the minister stands removed automatically. In the case of the PM and the CM, it's made a little bit different. So for the PM and the CM, they must resign themselves by the 31st consecutive day of custody. Assuming that they don't resign, by operation of this amendment, they would cease to hold that office. Okay, similar provisions have also been made for the union territories. Okay, but remember, the amendment says that if you get released later, nothing in this amendment is stopping you from being reappointed. Okay, so keep in mind, this is still a bill, it's under consideration. While it on its face appears to have some merit, there are also reasonable concerns that it may be used to target ministers of different ideologies than the one in the union government. Okay, so just remember, it's still a bill, it's pending consideration. How can it become an act and therefore amend the constitution? The procedure in Article 368 has to be followed, right? So I would advise you to quickly revise that procedure from the perspective of GK. Okay, let's now move on to the next. Yes, the other important topic which occupied the news for quite a while is the resignation of the vice president and the election of the next vice president. So basically, the vice president, Mr. Jagdeep Dhankar, resigned. He became actually the first vice president who resigned not to contest the presidential election. Otherwise, he is the third VP to resign. But the first two vice presidents to resigned only to contest the election for the office of president. Mr. Dhankar simply resigned not to contest the election for president. Okay. Now, let's have a very quick look at the office of the VP. As you all know, the vice president serves as the ex officio chairperson of the Rajya Sabha, which is the upper house of the Indian Parliament. And this is a concept that we have borrowed from the US. So, for example, in the US Vice President J.D. Vance also serves as the president of their Senate, which is their upper house. Okay. Now, let's have a very quick look at the various records relating to the vice president. So we have here, who was the first vice president? This is Dr. Sarvapalli Radhakrishnan. He is also the longest serving VP, having served 2 terms, which is also equaled by Vice President Hamid Ansari. Okay. Dr. Radhakrishnan, you should remember, was also the first recipient of the Bharat Ratna alongside C.V. Raman and C. Rajagopalachari. In fact, he is also the first recipient of the Sahitya Academy Fellowship. Okay. Now, Mr. Dhankar resigned. So the first question is, when the VP resigns, who should he address his resignation to? The answer is the VP can resign by addressing the resignation to the president. Similarly, the president resigns by addressing his resignation to the vice president. Okay. Now, since he resigned, okay, we don't have to get into the reasons for it, but since he resigned, a new election had to be held. First, keep in mind that the elections for both president and vice president are also held by the Election Commission of India through an electoral college. Now, who is in this electoral college? All the members of parliament of Lok Sabha and Rajya Sabha. Okay, all the MPs of Lok Sabha and Rajya Sabha are members of the electoral college to elect the vice president. The nominated members are not excluded. Whether you are elected or you are nominated, you have a right to vote at an election for the office of the vice president. What's the structure? The election is held by a system of proportional representation by single transferable vote by secret ballot. Okay. Now, this election was held. The National Democratic Alliance, led by the BJP, put up a candidate, Mr. C.P. Radhakrishnan, whereas the India Alliance or the India Bloc put up retired Justice B. Sudarshan Reddy of the Supreme Court as their candidate. the NDA candidate, Mr. C.P. Radhakrishnan, won, and he was sworn in as the 15th Vice President of India. Okay, so please keep this topic in mind. You need to know the basic records relating to the Vice Presidents. We already did the first. The longest serving is jointly held by two. One is Dr. S. Radhakrishnan and the other Mr. Hamid Ansari. Okay, who was the first Vice President to serve as acting President? The answer to this will be Mr. V.V. Giri. Okay, the answer to this will be Mr. V.V. Giri. He was the first Vice President to serve as acting President. So just remember, if the President resigns, dies in office, or is otherwise incapable, or is removed by impeachment, the Vice President serves as acting President till a full-time President is elected. Suppose the President and Vice President are both unavailable, then the Chief Justice of India serves as the acting President. And suppose all three are not available, then the next senior most judge serves as the acting President. Okay, so please keep these details in mind. Let's now come to our next topic. So another relevant topic from the perspective of the Constitution this year is 50 years of the internal emergency, and related to this, the government is observing Samvidhan Hatya Divas. Okay, now first keep in mind there are three kinds of emergencies in India. What are they? Number one, national emergency under Article 352. Number two, emergency due to the failure of constitutional machinery in the states, and this is also popularly called President's Rule. And finally, Article 360 dealing with financial emergency. Okay, so 352 national emergency, 356 emergency due to failure of constitutional machinery in the states, and 360 financial emergency. So please keep in mind, financial emergency has never been imposed in our country. The President's Rule kind of emergency due to failure of constitutional machinery in the states, that has been imposed countless number of times. Indeed, you have to remember about Article 356 and the President's Rule, even in relation to the state of Manipur, right? The state of Manipur at this time remains under President's Rule, under emergency, under Article 356. Okay, so please keep that in mind. Now, coming to national emergency, this is what we are concerned with when we are talking about internal emergency as well. Okay, now this, as I said, is provided in Article 342, and various grounds have been prescribed on the basis of which a national emergency can be imposed. Okay, so what are those grounds? So originally the Constitution said war, external aggression, internal disturbance. Okay, so the emergency which was imposed in 1975 was imposed under Article 352 on grounds of internal disturbance. Okay, so please keep that in mind. However, remember that this ground has now been removed. Okay, the ground of internal disturbance as a reason for imposing national emergency stands removed by the 44th Amendment. So as of today, national emergency can only be imposed on grounds of war, external aggression, or armed rebellion. Okay, so those are the three criteria for imposing a national emergency today. But at the time of 1975, a national emergency was imposed under 352 on the grounds of internal disturbance. Who proclaims the emergency? It is President Fakhruddin Ali Ahmad on the advice of the then Prime Minister Indira Gandhi. Okay, so please keep that in mind. An emergency has been imposed before this, but none after this. So before this, emergencies have been imposed two times. First in 1962 due to the India-China War, the Sino-Indian War, and in 1971 due to the Indo-Pakistan War of that year, also known as the War of Bangladeshi Liberation. Okay, and this was the third time and the final time till now that a national emergency has been imposed. Okay, so when was it imposed? It was imposed on the 25th of June 1975. Okay, and it is the 25th of June which the government is celebrating as Samvidhan Hatya Divas. Okay, this emergency was ultimately lifted on 21st of March 1977. And who was the person who issued the proclamation revoking the emergency? It was then acting president B.D. Jat. Okay, I've been saying to you in other videos that I want you to relate the topic of the emergency with the Press Council of India, because the Press Council of India is a body that was abolished during the national internal emergency. So remember, Press Council, statutory body, first chair J.R. Mudholkar, current chair Ranjana Prakash Desai. Okay, and link to it, National Press Day, 16th November, World Press Freedom Day, 3rd of May, the Guillermo Cano World Press Freedom Prize, won by La Prensa of Nicaragua this year, and finally, the World Press Freedom Index, launched by Reporters Sans Frontiers, or the Reporters Without Borders. Okay, so I hope these details are clear. Please keep in mind the government is observing Samvidhan Hatya Divas, and since 1975, it has been 50 years of the internal emergency. Okay, let's now move on to 75 years of the Supreme Court. Now, as you know, we've already done, it's been 75 years since the advent or commencement of the Constitution of India. This also means that it's been 75 years of the Supreme Court, and we'll see 2 slides down, 75 years of the Election Commission. Okay, so we need to keep these in mind. Now remember, the judiciary, the Supreme Court, the Election Commission, these would have been relevant for you in any case for GK. But considering that it's now been 75 years of their establishment, it becomes even more important. Okay, so let's just consider a few basic points. Number one, the precursor of the Supreme Court was the Federal Court of India. And the person who was the first Indian Chief Justice of the Federal Court was Sir Srinivasa Varadachari. We have covered him because he was also the chair of the first Central Pay Commission, and he was also the chair of the Ad Hoc Committee of the Constituent Assembly on provisions for the Supreme Court. Okay, and finally, the last Chief Justice of the Federal Court was the same as the first Chief Justice of India, that is Mr. H.J. Kani. Okay, Mr. H.J. Kani. Next, let's just quickly do a few of the records. So who was the first Muslim to be Chief Justice of India? It was Mr. M. Hidayatullah. Then the first woman, so till date, sadly, there has been no female Chief Justice of India. The first female judge was Fatima Bibi. And till date, in all of our 75 years, only 11 women have ever been appointed judges of the Supreme Court. So this is absolutely a dismal record. But in 2027, as long as the rule of seniority is followed, Justice B.V. Nagaratna will become the first female Chief Justice of India. Okay. Next, the first Buddhist. So this will get linked to our news this year because the 52nd Chief Justice, who has just retired yesterday, Mr. Bhushan Ramakrishna Gavai, B.R. Gavai, Justice B.R. Gavai, was the first Buddhist Chief Justice of India. Then the first Dalit Chief Justice was Justice K.G. Balakrishnan, the first Parsi, Mr. S.H. Kapadia, and finally the first to serve as acting president. So only one Chief Justice of India has ever served as acting president, and that is Mr. M. Hidayatullah. Okay. Last, we have the longest. So who is the longest serving CJI? It is Mr. Y.V. Chandrachud, father of D.Y. Chandrachud. So initially, when the Supreme Court was created, it was housed in the Chamber of Princes in the old Parliament building. But ultimately, it shifted to its new address. As I've mentioned for you here, the motto of the Supreme Court is Yato Dharmas Tato Jaya. Okay, so Yato Dharmas Tato Jaya. Okay, Yato Dharmas Tato Jaya. Where there is dharma, there shall be victory. Okay, so just remember, for the Supreme Court, there are a total of 34 judges. So 31 puisne judges and 1 Chief Justice of India. Okay, so 33 puisne judges and 1 Chief Justice of India. I don't want to go into too much detail right now on this, but please be clear on the appointment process. Judges of the Supreme Court are appointed through the collegium system. And this was a system created by the judiciary through a judgment known as the second judge's case, which was Kavra versus Union of India, and later clarified by the third judge's case, which was In Re Special Reference number 1 of 1998. Finally, there were some attempts by the executive to get into the process of judicial appointments through the creation of the National Judicial Appointments Commission by the 99th Amendment Act. So finally, in the fourth judge's case, again called Kavra versus Union of India, the Supreme Court declared that entire amendment to be unconstitutional and returned to the collegium system. Okay, so just keep that in mind. 3 basic details. When judges of the Supreme Court have to be appointed, the collegium comprises of 5 judges. Chief Justice of India, next 4 senior most judges. When we are talking about appointment of High Court judges, the collegium of the Supreme Court comprises of 3 judges, CJI plus 2. And when we are talking about transfer of High Court judges, once again, the collegium comprises of 5, the CJI plus the next 4 senior most judges of the court. Okay, so with these basic details in mind, I'm leaving removal for the moment because we'll discuss this with respect to Justice Yashwant Verma. Okay, now I put down 3 important pieces of news related to the judiciary this year. Number 1, as I said, relates to Justice Verma, Justice Yashwant Verma. Okay, this is the person against whom an in-house procedure was conducted by the Supreme Court and a removal process is underway by Parliament. Okay, the second piece of news relates to the 52nd and 53rd Chief Justice of India. So the 52nd was Mr. B.R. Gavai, the first Buddhist and the second Dalit Chief Justice of India. And now just today, the 53rd Chief Justice of India has been sworn in. What is his name? His name is Justice Surya Kant. Okay, I hope this is absolutely clear. The last one here is this book written by Justice D.Y. Chandrachud. The name of the book is Why the Constitution Matters. Okay, why the Constitution matters. Now, coming back to Justice Verma, so just a bit of background. So at his home in Delhi, he was then a judge of the Delhi High Court. So at his home, in an outhouse inside the compound of his home, allegedly a large amount of money was found after there was a fire. Okay, now this obviously raised issues of corruption, and it's obviously caused a huge dent to the image of the judiciary. Now, against him, 2 different processes came about. Number one, the in-house procedure, and number two, the removal or popularly impeachment process. Okay. So what is an in-house procedure? Remember, the in-house procedure is adopted by the Supreme Court in 1999. Okay. And this is not a procedure for removal. This is a procedure which is in-house. In-house for whom? So it keeps matters within the judiciary, and it's an attempt to reach the truth within the judiciary. Okay. So that's the in-house procedure adopted by the Supreme Court in 1999. So in this case, the in-house procedure was followed. A 3-member committee was established under the in-house procedure, comprising of Justice Sheel Nagu, Justice G.S. Sandhawalia, and Justice Anu Shivaraman. Okay, so this was the 3-member inquiry committee under the in-house procedure. Now, this committee conducted an inquiry, gave a report to the Chief Justice of India saying that the allegations appeared to be credible or true, and that they were serious enough that possibly the judge should be removed. Now, remember, there is no power within the judiciary to remove a judge of the Supreme Court or of a High Court. Okay, so that is not something that is available within the judiciary. So what did the Chief Justice do after getting this report? He wrote a letter to the Prime Minister and the President attaching the report and saying that we in the judiciary have conducted an in-house procedure and have found the allegations to be credible. And not just that, this appear to be serious enough that removal proceedings should be initiated. That is where the in-house procedure ends. This action of writing a letter is also in accordance with the procedure laid out in the in-house procedure. Now, separate from this is the removal process. Now, the removal process is provided in Article 124, Clause 4 of the Constitution. Okay, and the same process applies to the Supreme Court judges, to High Court judges, to the Chief Election Commissioner, as well as to the Comptroller and Auditor General of India. Okay, so who has the power of removing a judge of the Supreme Court or of the High Court? It is only Parliament, right? So Parliament has to present an address to the President, who then issues the order for removal. Now, in India, judges can only be removed on 2 grounds, judges of Supreme Court and High Court. Number 1, proved misbehavior, and number 2, incapacity, which can be mental or physical. Okay, and what majorities are required in each house of Parliament to remove a judge? Number 1, 2/3 majority of those present and voting, and number 2, simple majority of the total members. Both of these conditions have to be satisfied simultaneously and in both houses separate. Okay, there is no provision of a joint. Okay, now the procedure is bare bones in Article 124, Clause 4, and so this has been supplemented by the Judges Inquiry Act. Okay, the Judges Inquiry Act. So this lays out the exact procedure to be followed. And so in the case of Justice Yashwant Verma, a notice was given by the requisite number of members of Parliament, and it was admitted by the Speaker of the Lok Sabha, which is right now Mr. Om Birla. Okay, so as per this removal process, as per the details of the Judges Inquiry Act, a 3-member committee was formed. Okay, what is that 3-member committee? Number 1, it has Justice Arvind Kumar of the Supreme Court. It has Justice Manindra Mohan Srivastav, Chief Justice of the Madras High Court, and finally, Senior Advocate B. Vasudev Acharya. Okay, so Arvind Kumar of the Supreme Court, Manindra Mohan Srivastav of the Madras High Court, and B. Vasudev Acharya, a senior advocate. So this committee was established in accordance with Judges Inquiry Act, read with Article 124, Clause 4. Their job is to conduct an inquiry and submit a report to the Speaker. If they say that the allegations are false, the process cannot be taken any further. However, if they say that the allegations are true, then Houses of Parliament get to vote on the motion to remove the judge. In this case, Justice Yashwant Varma. Okay, so I hope these details are clear to you. Now, today we've taken a look at quite a few important topics related to the Constitution. I don't want this particular video to drag on. So what we'll do is I'll make a part 2 of this video so that we are able to cover the other important topics which are still left. Okay, so stay tuned for part 2. Today in part 1, we've covered the basics of the Constitution and constitution making. We've also focused on 75 years of the Supreme Court, the removal process and in-house procedure of just relating to Justice Yashwant Varma, the latest CJIs, the book known as Why the Constitution Matters. We've also taken a look at the latest 130th Amendment Bill. Okay, so that's basically half of what I wanted to cover. There's a part 2 coming. So stay tuned. I'll try to make that video tomorrow. Okay, so I hope these last lap revision videos are useful for all of you, and we'll keep coming with those. As I've said in the past, over the next 3 days or so, we have videos. There'll be part 2 of the Constitution news video. There'll be the defense video. There has to be an environment video, and finally one on the Israel and Palestine issue. Okay, so please stay tuned, and I'll see you all soon. Thanks everyone. Bye-bye.